Hello, everybody. Sharon Adams here to talk about trademarks. This time I'm going to talk about the difference between an intent to use trademark application and a trademark application that is filed as in use. So just as an upfront, sometimes I call trademarks brand names, so I may use those words interchangeably in this video. Now, an in-use trademark application means that the trademark is being used on the goods or services that are identified in the trademark application, and that they're being used at the time the trademark application is filed. So, for example, if an applicant were filing a trademark application for clothing and the application was in use, then at the time the application was filed, there would have to be evidence that the brand name was used on the clothing, and this would have to be submitted with the trademark application. And that's included in the filing fee that the US Patent and Trademark Office, the USPTO, charges. Now, an intent to use trademark application can be filed when the trademark or the brand name is not actually in use. So a business may be in product development and they may want to know if a particular brand name will become a registered trademark, whether this company will have the rights to this brand name. So in those scenarios, it can make sense to file an intent to use trademark application. That way, the trademark application is examined by the USPTO, and if everything looks pretty good, then, if the USPTO approves it, then that intent to use trademark application will receive what's called a notice of allowance. And that means that the USPTO has examined it and basically it's pretty much set to go forward. And what is required is that the applicant must show that it is using that trademark before the trademark will be registered, because all registered trademarks in the United States must show that they are being used in commerce before the USPTO will register them. So the reason I wanted to explain this is because it can be more expensive. It is more expensive to file an intent to use trademark application. So basically everything is the same at the start. File the trademark application, the USPTO charges a filing fee per classification. That is all the same, whether it's in use or intent to use. However, as I said, it's examined. The USPTO will examine these, so the procedure is the same. And if the trademark application is in use, then the trademark application will go on to registration, assuming there's no other issues going on. And that's how it works. Whereas if it's intent to use, you file the trademark application, you pay the USPTO filing fee, the USPTO examines it, and then if it looks good, as I said before, the USPTO will give a notice of allowance. That is not a registration. The applicant still has to show that they are using the trademark on the goods or services that are identified in the trademark application. Now, their USPTO charges another filing fee to do that. So again, the USPTO charges a filing fee per classification to file the document that shows that trademark is being used on those specific goods or services. And that document, it's called a statement of use, or SOU. That statement of use must be filed within 6 months of that notice of allowance. So you get a 6-month period after the notice of allowance to file a statement of use. If the applicant cannot file a statement of use within the first 6 months, then the applicant can request an extension of time, and the USPTO charges a fee to request an extension of time. So every 6 months after the notice of allowance, an applicant must request an extension of time up until the point when the applicant can show use in commerce. So that's how an intent to use application can get to be expensive, because every 6 months that USPTO filing fee rolls around and it has to be paid to keep the application alive. If it's not paid, the application will be abandoned and the USPTO will cancel it. Now, the final caveat is that the applicant has a total of 36 months after the notice of allowance to file a statement of use. So you can't file them indefinitely. You cannot request extensions of time indefinitely. You can only have up to 36 months after the notice of allowance to file a statement of use. But as I said before, a request for extension of time must be requested every 6 months until that statement of use is filed. So it is definitely less expensive to file an application as in use because you avoid all of those subsequent fees from the USPTO. And if you're using an attorney, you avoid additional attorney time that's required, to file a statement of use or to request an extension of time. Another thing to say that does happen with intent to use applications is sometimes what the applicant states at the beginning of what they think their trademark is going to be for, the goods or services that are identified. Perhaps during the time, those goods and services are slightly modified, and sometimes the description in the intent to use application turns out to not be exactly what is in the final product or service, and that can cause problems with showing use in commerce at a later point. I'll do another video on showing use in commerce. That's an entirely separate subject. Final point, just to bring it home, if you want to file as in use and you've got your product or service and you've got your brand name on it, that is a less expensive way to go and sometimes a more certain way to go. However, if you want to preserve your rights to a brand name, you want to make sure that you're going to have that brand name when your product is ready to launch, then an intent to use application can be a great way to protect your rights while your product is being developed. And if you need any help with trademarks, please contact me, Sharon Adams, at Adams Law Office in Berkeley, California. Thank you.